Good morning, Your Honors. May it please the Court, Thomas Hudson on behalf of the retired elected officials, and with me at council table today is my partner, Sharad Desai. Your Honors, this case is a paradigm example of a legislature crossing a bright constitutional line. Arizona is one of a handful of states.
In the situation where the legislature passes an increase like this one and realizes subsequently because of the payouts that it made a mistake, under your theory of this case, short of changing the Constitution, there's no way they can fix that.
Let me address that in two ways, Justice Britnell. First, we fundamentally disagree that there was any kind of mistake. And in fact,
so for the sake of discussion, there was.
Okay. If you assume, and just on that point, I'd ask that the Court, if it hasn't, look at page 63 of Mr. Murphy's deposition, where he admits that there was no mistake. But let's assume, hypothetically, that there was, in fact, a mistake. Absolutely. The only way that what Article 29 does structurally is several key things. In the first clause, it addresses funding. And it says, here is how you fund public retirement systems. And that's through two means, contributions and investment returns. And the funding must be done in an actuarially sound manner. Then we go to Section C, which talks about benefits. And as Justice Bales and Justice Birch noted, Section C has two clauses. The first deals with membership rights generally. The second deals with retirement benefits. And with retirement benefits specifically, it uses the language shall not be diminished or impaired, as does a handful of other states. So Article 29 we submit was intended to address this particular situation. The voters intended to bind the legislature, bind future legislatures. It's understood that they're going to be tempted to take money from benefits. Section A, which addresses funding.
Why should we impute that intent to the voters? I don't see anything on that topic in the voter pamphlet or in the arguments for or against the ballot measure.
So actually, Justice Bales, if you look at the very first argument in the publicity pamphlet is a comment from a senator at the time.
This is Senator Spitzer's comment?
Senator Spitzer, and it notes that it talks about the COLA, and in the last clause there says it is critical to this state that retirees be guaranteed that their retirement benefits will not be impaired. And we submit that the language benefits shall not be diminished or impaired is that guarantee.
So if the legislature passes a statute which makes up a formula on a Monday and then on Wednesday decides to change it, they're constrained from doing so under the Constitution?
It would depend on what the formula said, Justice Timmer.
Let me be more specific. If a month or so after the 1998 formula statute was enacted, the legislature said, oops, we certainly did not intend, and we seriously doubt that the electorate of Arizona intended to have a scenario which we now have, which is retired people making more in retirement than they made at their highest point of earnings while working. And they say, we didn't intend that, we need to change that, and a month after the 1998 statute does change it. If I understand your arguments correctly, that change would not apply and could not affect the retirement benefits, including future adjustments for all of the retirees.
That is our position, Justice Planter, and I would note that certainly this case would be much more difficult that immediately, of course, the legislature referred Article 29 to the voters.
Mr. Gruby, I think, accurately acknowledges that this case in large part hinges on the definition of benefit. And Article 29 and the Arizona statutes that are relevant to this case do not define that term. So we're left with figuring out how should it best be defined. The trial court's ruling, as I read it at least, relies on common sense, common usage, and whatever, but really doesn't give a reasoned principled basis as to why the judge came up with the definition that he did. And so we're looking for help. And I know it's been well briefed and so forth. My question is, why should we give a definition to the term benefit as broadly as your argument would have us do if by doing so we undermine the apparent purposes of subsections A and perhaps even B of Article 29?
Okay, let me address that in a couple ways. And before I do, let me just note, too, on the previous questions that were suggesting the only method is a constitutional amendment. I think it's important to note that it's easier to amend the Arizona Constitution than the federal Constitution. So that is a real option. Now, with respect to the definition of benefit, we would submit that you look at common usage, ordinary language, as you would interpret any other statute. And with respect to this argument that really benefit means the base benefit, if the voters and the legislature in referring this to the voters had intended to limit the protection to a base benefit, it would have been easy for them to say that. They didn't. It doesn't say benefit singular. It says retirement benefits, plural, shall not be diminished or impaired. And we would submit that when you think about what retirement benefits are the entitlements that a retiree was promised to be paid in retirement. And when you look at dictionary definitions, it talks about payments under a pension or an annuity, which necessarily includes the method by which those payments are going to be calculated.
But how do you respond to the position that URP and the state have taken that you're not really entitled to these possible future increases until the circumstances that would trigger them actually occur? And they're different than an employee simply serving the term of years that's required to qualify under a plan, because it's a contingency other than their continued service.
Your Honor, the retirees in this case did everything they needed to become entitled to their benefits.
No. I guess I didn't answer my question. I didn't ask my question clearly. I think the state and URP is distinguishing what the employee has to do to be eligible, serve your time, basically, as opposed to a different contingent future event. And they would argue that the latter means that they aren't really entitled to the benefit for purposes of Section 29.
Thank you for that clarification. And I guess let me say a couple things on that. Our position is it's the right to have the benefits paid as promised that vests. And the fact that you're promised a formula that in and of itself may depend on some future contingency doesn't change the fact that you have a vested right to be paid as promised. And so it's the right to be paid in accordance with the formula that involves no contingency whatsoever. That vests upon retirement. The day you're retired, and of course the statute says that. The statute uses the word entitlement in the context of the very history that you identified. It says you're entitled to be paid this base benefit. It's that right to be paid in accordance with the formula that vests. And we gave the example in our brief. I mean, it seems it would be an easy case if you purchased an annuity and it promised to pay sums over a period of years, and it promised that they would be increased if, for example, the Dow went up by 9%. The insurance company, if it tried to say, oh, we're going to take that away from you, but we're not reducing your benefits, would be laughed out of court. It just runs completely contrary to the ordinary use of language. And so
I just wanted on that point, the publicity pamphlet said in the legislative analysis that whatever the proposition was, 100, I believe, the rules are consistent with current law and practices. So the examples that you're giving in the application of the second clause of Article 29.1, would that have been in effect prior to enactment of the proposition?
Prior to the enactment of Proposition 100, there had never been a reduction of a benefit that had been promised. They were either sunsetted or they've been changed. And historically and in the context of when that was enacted, it would be inconsistent with practice.
What about the law, though? So what I'm going to get to, of course,
okay.
What was the law prior to Proposition 100 which enshrined the interpretation that you're advocating today?
In terms of Arizona law, we had the Yazell case and we had the fund manager case. And prior to the adoption of Article 29, there had never been a case where a court had taken away a vested benefit. And in fact, when you look at fund manager and Yazell, fund manager only gets to the contract clause analysis after concluding that the benefit had not been vested. And after making that conclusion, it then applies a contract clause analysis. So at the time Proposition 100 was enacted, there had never been a reduction of a vested benefit. So that was the context, and it was saying consistent with law and practice, and as I noticed, certainly the practice was not to do that. And that was also consistent with the law, but that's not all the publicity pamphlet said. It had the words of increasing the protection afforded to retirees. The arguments were that we need to guarantee the benefits. So it was made clear to the voters that this was going to be the kind of protection that would deal with this case. Here we are in 2013, where the legislature's tempted to solve a funding issue by taking money away from the retirees, and Article 29 says you can't do that.
You just said in your answer that they had never taken away a vested benefit.
Correct.
So do you agree then with Mr. Gruby that the benefit referred to in the second clause in 1C has to be a vested benefit?
We don't, but we don't think in this case it changes the analysis. We think the benefit is so clearly vested. I mean, in our view, this is the easy case. This is the retired members. The benefit's clearly vested. They were told it's an entitlement. They had done everything they need to do to earn the benefit. That this case is not going to turn on that distinction. But as you noted, Justice Timmer, the clause says benefits should not be diminished or impaired, and we think the natural distinction there is between membership rights generally and retirement benefits in particular.
What's an example of a membership right that's not a benefit?
Contributions would be one. The right to purchase additional benefits would be another. There's benefits that are afforded when people return to work. So there's a variety of benefits incidental to membership that are valuable to members in the plan, but are distinct from the retirement benefits, which the voters said we're going to protect those. Those shall not be diminished or impaired. And I would note too that in terms of the relationship between Section 1A and Section C, and this argument that somehow the actuarial soundness of the plan allows benefits to be taken from retirees, Section 1A doesn't say that. It says, here's how you solve funding issues have to be solved through contributions and investment earnings. And then you get to Section C, and it's not qualified. It doesn't say, subject to Section A, benefits shall not be diminished or impaired.
How about subsection B? The trial court didn't address A or B, and B talks broadly about all members of the plan, not just retirees. So what about, where does subsection B fit into the equation?
Subsection B is sort of directed at a particular another evil that the voters were.
I know it's talking about you can't rate it, you can't sweep it, and
Correct.
so forth, but it goes on and says that the plan shall be invested, administered, and distributed as determined by law solely in the interests of the members and beneficiaries of the public retirement system. So it's not limited to the subset of retirees, i.e. the class that you're representing here.
Right, but our view is that it is intended to sort of address this issue of rating. And again, nothing in B.
Well, again, I'm focusing on it's one sentence. It's not that complicated, and it clearly talks about broadly the entire membership of these retirement plans.
Right, but so I guess I'm not following how that impacts section.
Well, we're focusing obviously on your argument on the second clause of subsection C. And Article 29, which after all was adopted as a whole back in 1998 by the electorate, is all one piece of the Constitution, and we have to look at it cohesively and coherently and harmonize the different subsections. And I'm having some trouble trying to reconcile your broad definition of benefits with the with the obligation that A and B seem to put on actuarial soundness in A and administering on behalf and for the benefit of all members of the plans in B.
Yeah, so Justice Plander, we agree completely that the provisions need to be construed as a whole, and we think sticking to the plain language is the best way to do that. And the second clause in B that talks about investing and administering and distributing as determined by law in the interest of the members is in no way inconsistent with the again, heightened, specific, particularized protection given to retired members in terms of benefits.
Well, maybe not. I mean, this is where the legislative findings in 2011 that underlay the SB 1609, which are very specific about the actuarial unsoundness and the fact that this is going down the tubes, as are these other plans, quickly. They're way underfunded. Nobody disputes that, I don't think.
Right, and of course Article 29 says how to address that. And let me note a couple things in terms of Section C. nothing in the language and nothing in the publicity pamphlet in any way suggests that the voters intended that to be subject to any exceptions. It doesn't. It would have been an easy thing in 1998, after this court had issued Uzell, for the legislature to have included, or the voters to have included in their language that said, benefits shall not be diminished or impaired unless it is necessary to address an issue of actuarial soundness. But Section C is in no way qualified. It doesn't say subject to Section B. It doesn't say subject to Section A. So you've got the plain language, you've got the text, you've got nothing in
But it is bizarre to do Section 25, and yet we read the ability of the legislature in the right circumstances to impair a contract. Why shouldn't we do the same thing with regard to the second clause of paragraph C?
For a couple reasons. One, they are distinct clauses, and had the voters intended to engraft the contract clause analysis onto the second part, it would have. I think it also, I think it matters.
The drafters of the Arizona Constitution, can't you?
But I think it matters that this was a referendum in 1998. This court has made clear that it interprets constitutional provisions referred to the voters in accordance with their plain language. And I think it's, as a matter of basic jurisprudence, it's good law, it's good jurisprudence for courts to say again to the legislature, to the voters, mean what you say what you mean, and we'll enforce that. And if the voters had intended there to be exceptions, they would have included them. And this court can't write into the...
Do you require the plain language of subsection A to require the plan to be actuarially sound?
I construe it as requiring the plan to be actuarially sound by funding it with contributions and investment earnings. That's what it says. It says that funding comes from two sources, investment earnings and contributions.
And if the legislature passes a statute which creates a COLA system which is arguably actuarially unsound, the provisions of Section 1A don't apply to that.
They tell the legislature exactly how to fix the issue. And so really, again, structurally, Article 29 gives the legislature many options, but it takes some of them constitutionally off the table.
I want to go back, if you're finished, to the question Justice Palander asked about the interplay between subsection B and C, because I think this is suggested in the briefs either by the state or EORP. One way to read B is to say that, investment earnings ought to be invested for the interest of the members and beneficiaries in general. And you ought to read the restriction in subsection C in light of that and allow what's happened here, which isn't reducing benefits systemically. It's saying that we're going to reallocate, we're going to prevent this siphoning off of investment earnings to benefit just a particular group of beneficiaries, and instead put the money back in to the general retirement system account so it'll benefit all the beneficiaries.
Right, but B talks about investing, administering, distributing benefits. It doesn't say you can solve an issue of unfunded liability by taking away the benefits that were promised to retirees. Nothing in that clause can be construed to give it that broad of a meaning, particularly given the specific language of Section C.
I don't think that fairly characterizes the argument the other side's making. As I understand it, I think what they're saying is, look, you shouldn't characterize as a reduction in public retirement system benefits what happened here, because it's essentially saying that instead of siphoning off part of the investment earnings just to increase benefits in a non-sustainable way for a subset of the plan members, we're going to push that money back into the general trust fund assets, and it'll benefit everybody. And that's consistent with the directive in B. And to allow that, you ought to read B, or you ought to read C narrowly. I think that's what they're saying.
Yeah, I understand the argument, but I guess what we would submit, Justice Bales, is that certainly the constructions that's most consistent with the plain language doesn't permit that. It does. Nothing in B says that when you're thinking about how to distribute the assets, one of the ways to do that is to cut retirement benefits. So I get the argument, and I guess let me say, and if I can in my final 20 seconds.
It's sort of an anti-Three Musketeers. You can't say that we're going to cut for one to benefit all.
Perhaps. We, and this is addressed in the briefing, but this notion of the actuarial soundness and so on, there were other solutions to this that the legislature should have and could have considered. And again, if there really is sort of the ultimate plan going bankrupt, then there is the option. And we cited these cases in our brief, but I would note that courts, we're not the first court to face this temptation by the legislature, and I would just point, I think the Birnbaum case and the Booth case are good examples where, when faced with the argument that the plan would be plunged into bankruptcy, said the answer to that argument must be that we are not at liberty to hold otherwise. And we would submit that Article 29 ties the court's hands. The legislature crossed a bright constitutional line, and we would ask the court to affirm.
Thank you, Mr. Hudson.